Should you contest a will? The answer lies in whether you feel you should have received an inheritance from a loved one who promised they would leave you something in a will. I'm Reed Bloodworth, the managing partner of Bloodworth Law. Our offices are located at 801 North Magnolia Avenue, Suite 1600 in downtown Orlando, and at 332 Avenue B Southwest in Winter Haven, Florida. Bloodworth Law handles probate and estate litigation for plaintiffs and defendants in Orange County, Seminole County, Volusia County, and many other counties and courts throughout Florida. If you were surprised that you were not named a beneficiary in a will, or someone else received what you thought or felt that you should have received in probate, the decision is yours as to whether you should contest a will. However, if a potential beneficiary or a plaintiff fails to contest a will within a set timeline and in accordance with the law of Florida, those claims are forever barred. You must act immediately on your claims. The first thing you should do is meet with an attorney who handles probate litigation and who can properly contest the will. Anyone, including a family member, a friend, creditor, even a nonprofit organization, can contest a will. If someone believes that they were left out of a will as a beneficiary, or feels that someone else inadvertently or intentionally received the estate's assets, then that person or entity can contest the will in probate court. Probate litigation is legal action taken to dispute the benefits or actions surrounding a will during the probate process in a Florida probate court. At Bloodworth Law, the most common probate litigation we see usually involves a claim by a beneficiary or would-be beneficiary filed against a personal representative or another beneficiary because they didn't receive a specified benefit or inheritance from a will. A beneficiary is a person who receives money or assets or property from a will. On the other side of will contests, we represent defendants accused of illegally receiving benefits from a will or taking assets during probate. Defendants include executors, personal representatives, and other beneficiaries. So let's go back to the question. Should you contest a will? Ultimately, it comes down to a decision you should make with your attorney after analyzing the available evidence. You should discuss with your attorney how you both see the litigation playing out. If you believe something's improper with the will, then that's the moment to act. There are a few common red flags to look for when deciding whether to challenge a will. 1, the decedent's will is amended or recreated shortly before his or her death. 2, property is transferred away from the decedent shortly before death. And 3, the decedent's banking, investment, or retirement accounts were amended to add a co-owner or a different payable upon death beneficiary. While an effective way to avoid the necessity of banking and investment accounts passing through probate, sudden changes before death can raise questions. All of these red flags can give rise to accusations of undue influence, lack of capacity, or tortious interference with a testamentary inheritance. However, the flip side of this is that there are many cases where there is no foul play, and a personal representative can be defended for doing as instructed by the decedent's will. Again, I'm Florida attorney Reed Bloodworth, the managing partner of Bloodworth Law. Talk with an experienced probate lawyer if you believe you should be a beneficiary in a will, or if you need to defend yourself against claims of wrongdoing. If any of these situations come up and you're questioning what to do, give me a call. Let's talk about how Bloodworth Law can help you or your family.